First case is Starboard Cruise Services versus Thomas Deprince.
Good morning. May it please the court. Eric Isikoff and Carolyn Latour on behalf of the appellant, Starboard Cruise Services, and I would like to reserve 2 minutes for rebuttal.
Thank you.
So I'd like to start by briefly addressing the issue of ambiguity. The trial court held, we think correctly so, determined that the offer of settlement, putting aside whether it's valid and enforceable for other reasons, was a model of clarity. He stated in his lengthy order that it could not possibly be more clear, and I would agree. Again, there are other issues I'd like to get to with respect to this in an action for damages Diamond Aircraft conundrum, but as far as the clarity of the offer itself, the rule was followed. It was very clear. There's no internal inconsistencies. There's no inconsistencies between what was placed in the proposal and any attachments, like, for example, a notice of dismissal or release. The cases they've cited, Cyan's, Hilton Hotels, the supplemental authority that they submitted on Friday, every one of those cases has either a clear internal inconsistency in the body itself of the proposal, or in the case of the supplemental authority, you have inconsistencies that are very clear between either the offer and the notice of dismissal or the offer and the release. One says one thing, the other says another. There's an inconsistency, ambiguity, not applicable here. So I would like to talk about this evolving area of law that we find ourselves dealing with as a result of the Diamond Aircraft case. I would submit to the court that Diamond Aircraft certainly acknowledged that it is not a black and white rule, and that case spoke approvingly of the Di Pompeo and Nelson Marine cases, recognizing that there is a true relief look behind the procedural vehicle approach that the court must take. Otherwise,
so I think the concern here is the specific performance count and the timing. You know, is it a real specific performance count, real equitable relief pending, as opposed to a make-weight declaratory judgment as to one element of a contract claim? Those seem to be distinguishable to me. So if you can focus on the specific performance count for this particular diamond.
So I think the reason why this case falls outside the grasp of Diamond Aircraft is because if any of the cases that have been discussed and cited, even in supplemental authority that they filed, cases that are not binding clearly, not even on their own courts, these are unpublished opinions, for example, of district courts, the 11th Circuit Court of Appeals. There's a discussion in the Mid-Continent case of the MYD Marine case. It's very brief and very concise. But I think of all the cases that discuss our issue here today, that's maybe the closest. Judge Salter, to your point, in that case, MYD Marine, there was a lawsuit brought under the state antitrust law alleging a price conspiracy among distributors of marine paint. There was also a claim for damages brought in that case. And the way it's described in the Mid-Continent case that they've submitted as supplemental authority is distinguished in that case. And what they say is that the plaintiff in that case abandoned the injunction claim and decided, put their money behind the damages claim, and know that case, that claim.
But in this case, Prince didn't abandon the specific performance claim until after the offer of settlement was
That is true.
Was proposed.
That's true. The timing is such that it was dropped.
And you would agree that Deprince, I mean, not knowing at the time that this diamond was not available, I mean, that Starboard didn't have the diamond, the supplier didn't have the diamond, at the time of this proposal for settlement, Deprince did not know that, and so would have been very happy to have either the diamond or the value of the diamond to resolve the lawsuit, correct?
I don't think that that's factually the case. I don't want to fall into the trap of we're arguing that this is a meritless claim and so forth because Diamond Aircraft says we can't go there, and that's not our position. But very early on, and from the very outset of this case, it was well known that my client had not even ordered the diamond. We never had it. We never ordered it.
Did you move to dismiss that claim then based upon that fact?
We moved to dismiss it twice.
And it was denied?
And it was denied.
And was that argument made at the motions to dismiss that Starboard didn't have possession of the diamond, nor did its supplier?
I don't remember exactly what was argued in the state court at the time. I mean, I made the argument, but it was a long time ago. This case has been around for quite some time now. I don't remember all the things that were argued, but it was denied. And I guess the point here, though, is if we look at true relief, if we look at looking behind the procedural vehicle, this case always was about the value of the diamond. We never had it. That's been known from the beginning.
Let me ask you this question. If you truthfully believe that if the breach of contract claim was dismissed with prejudice, that the specific performance claim would by necessity also fail, then why, in making the proposal for settlement, did you include the specific performance count in
So I understand.
I mean, if you just felt it was normally going to go by the wayside, then why did you feel the need to require that all claims be dismissed with prejudice?
So there was the possibility that if we were to offer money to settle the conversion and the breach of contract claims, they would accept, because we put $75,000 on the table, we didn't offer them $1,000, a lot of money because of how much this case cost to litigate. So, sorry, we put a bunch of money on the table. They could have accepted that and decided to go to trial on specific performance. And that's a risk that I think was not a logical risk to take. But I will say, though, that the breach of contract claims subsumed.
Counsel, how's that right? Because if they accepted it, as I read the release, they would have A, been required to voluntarily dismiss those remaining counts, and B, they would have been released from all counts that were in the amended complaint.
Your Honor, that's 100% correct.
So they couldn't litigate that if they accepted the offer.
No, that's why we made the terms what we did.
I know, counsel, what I hear you saying to Chief Judge Rothenberg is that if they had accepted, they could have then accepted, taken their $75,000 and gone to trial on specific performance. I don't see how that can be true if the release released them, or released you, from all claims in the amended complaint, including that, and required the execution of a notice of voluntary dismissal for all counts.
It would have done all of that.
So then how can you, what you're saying to the Chief Judge, how can what you're saying to Chief Judge Rothenberg be correct?
I think I'm misunderstanding the question then, if that's your point, because what I'm saying is if we had not had them sign a release, had not had them dismiss that remaining one count, that was the point I was getting to.
Then why isn't that dispositive?
Well,
If Diamond Aircraft says that the general release is one that resolves, that's the word it uses, resolves all claims, and this would have, for all intents and purposes, resolved all claims, how do we get much further than that?
I don't think that that's what Diamond Aircraft said. I think
It doesn't use the word resolve all claims?
it uses the word resolve all
It uses
claims.
it like 3 or 4 times,
But
doesn't it?
our case is different.
Counsel, does Diamond Aircraft use that word 3 or 4 times?
At least.
Okay.
At least.
So doesn't this resolve all claims?
Well, it does resolve all claims, but it's the way in which the offer was constructed.
I guess what I'm asking is it really,
It's different.
does Diamond Aircraft saying we have to parse out each that it resolves all claims, but it does so in one way that it's okay, but another way that's not okay? I don't know.
I don't think it requires that. I said another way, I think that the way that the offer was constructed in this case was where we were mindful of Diamond Aircraft, mindful of the statute, mindful of the rule, and constructed an offer that fit within all of that.
I don't say that you
Diamond
didn't.
Aircraft says
I'm not
no.
saying, counsel, you didn't try, but it would seem to me that if you were truly mindful of those things, and you may not have been because the offer came before Diamond Aircraft came out.
We were certainly mindful of this problem.
Right, but if you were mindful of the problem, it would have been, I think as Chief Judge Rothenberg says, you dismiss count one, and you settle count one, and you dismiss count one, and you release count one with no mention of anything else whatsoever. And we certainly wouldn't be here if that was the case.
That's true. And the flip side of that is, for example, looking at the offer as it was made in this case, if they had decided instead of dropping, which they did voluntarily, dropping before trial their damages claim and decided to roll the dice and go with a specific performance claim, which they could have done, having rejected our proposal for settlement, we wouldn't be here once again because we would have no claim for fees.
I recognize that the way that the law has progressed in this field, it makes it almost impossible to make offers of judgment, because most claims or most complaints also include equitable claims, and so it's going to be a real problem going forward. But if you knew that Starboard didn't have the diamond and that its supplier didn't have the diamond, then probably the best thing, in hindsight, would have been to just make your offer of judgment on the breach of contract and conversion claims, it's rejected, and they go forward on, or let's say they accept it and they go forward on the specific performance claim, they're going to lose. And so you had to separate out the two and let them roll the dice and at least get your attorney's fees, going forward on whatever you could. I mean, if they rejected it, then you get your attorney's fees, at least on the breach of contract or conversion.
I understand that. I
And you
think,
didn't have the benefit of Diamond Aircraft. That
Oh, you
appears to
did.
be-
Diamond was 2013.
yeah, we
Proposed
understood well the
2013.
problem. We did. So in sum, because I know my time is limited, I don't think that Diamond Aircraft applies to this case. I don't believe we fall within its grasp. I believe that this case falls in line with Tower Hill. The decision.
The Javellana case.
Pardon me?
Tower Hill v. Javellana.
Yes, the Tower Hill case, I believe, this case is much closer to that. It cites approvingly to D. Pompeo. We have Nelson Marine, and I think the case that really speaks to this case the most of any other is the MYD Marine case, because of the abandonment of the equitable claim.
I have one more question before you sit down, and I appreciate you summing up as quickly as you can.
Yes, Sean.
One of the supplemental authorities that was cited was MDS Canada versus RadSource. Have you had an opportunity to take a look at that?
That was one of the last ones that came on Friday.
It was either Friday or the Thursday before, yes.
Okay. Yes, I looked at all the.
Okay, I just want to make sure. I don't want to ask you something.
Yeah, no, I've looked at all the cases.
Okay.
they submitted.
It's interesting because it's different than all the others. In that case, they did exactly what I suggested you should have done, and what I think Chief Judge Rothenberg suggested you should have done. It just did it on the damages count. And still, the court said that because it's an issue that was left open by Diamond Aircraft, and given the presumptions that we must follow under Florida law, the court said that it was still an invalid option. So even if I see this as falling in the gap of Diamond Aircraft, which you suggest, and you did it the right way under Diamond Aircraft, they still found that it was not a sufficient offer under the statute.
And my answer there would be, as I said earlier, it's not binding on this court. These are persuasive cases that are coming out of different
It's an
courts.
interesting discussion, though.
It is. A lot of these cases have interesting discussions. They're all over the place and they're all over the boards in terms of how what seems like a pretty straightforward rule should be applied.
And not on this issue. This is unless there's another one that I haven't seen yet, on this issue of falling in that gap that's identified in Diamond Aircraft. This is the only one I've seen that's actually ruled on it and has laid out why under Florida law it would not be applicable. I just wanted you to comment on that.
Yeah, I don't think it's binding here. I don't think it's necessarily the right decision. I think it carries forward faith freight forwarding, a case that Judge Rothenberg was on that panel, which spoke approvingly of D. Pompeo and recognizes the gap. I believe we fall within the gap here. And again, the main point that I want the court to consider is, unlike most of the other cases, but very much like MYD, they abandoned voluntarily their claim. There's no way when the jury came back that they could have gotten anything other than money damages. The decision they made, and I don't think the timing has been precluded by any of the decisions I've seen as the factor that would be most applicable here. That they, before this case went to the jury, dropped that claim. Only money damages was the only relief they ever could have gotten, period, no matter
They
what
did it
happened.
so close to trial that
They
they
did.
didn't have time to renew the proposal for settlement
Wait,
and give
It
them
was
30
literally
days.
on the eve of trial.
Yeah.
And again, there's teachings in these cases about warning for litigants to try to do an end run around the rule and the statute and why it's here. And we spent a lot of money on this case, and we made a very significant offer to them. So those are the factors I think the court should consider. I don't think we are precluded by Diamond Aircraft. Thank you.
Thank you very much.
Good morning, and please the court. Mario Ruiz of McDonald Hopkins, representing Mr. Deprince. This case falls squarely within the Diamond Aircraft case. Factually, procedurally, it's extremely similar in that you had both a contract claim and an alternative count for specific performance. And I want to emphasize the fact that it was an alternative count because the cases relied upon by the appellant, NYD Marine and Tower Hill, are different than this case and also different than the Diamond Aircraft case.
But could you address MYD Marine Distributor? Because that one is more similar to this case. And it did come out after Diamond Aircraft. Is it in conflict with Diamond Aircraft,
No.
which is a Florida Supreme Court case, or does it carve out an exception that we should adopt in the third?
You should not adopt it in this case, Your Honor, because, for a number of reasons. Number one, the offer of judgment in MYD was very different than the one made in this case. In MYD, the offeror specifically carved out the injunction relief and said specifically, this offer of judgment does not dispose of the injunctive relief claim.
The holding though in MYD is that what matters is the true relief being sought by the equitable claim, correct?
Correct.
We've already adopted that holding in Tower Hill, have we not?
You did.
So then what, we have adopted for all intents and purposes what the fourth did post Diamond Aircraft, right?
But in my position, yes, Your Honor.
Okay, so the question here is what is the true relief being sought by this alternative claim? Was it a real claim, as you're saying?
It wasn't.
Or was it in fact what your opposing counsel says, which is you knew from step one that they didn't have the diamond.
That's
This
not-
was all done as a ruse to get around the proposal for settlement.
May I address that, Judge?
Please?
Okay. Our specific performance count was count one in our complaint. It was the preferred remedy that Mr. Deprince wanted. In our case, unlike the NYD case and the Tower Hill case, where these were throwaway claims for equitable relief, in our case, the specific performance count was heavily litigated at both the trial court level and when we came before this court after Starboard obtained their original summary judgment. Judge Rothenberg, you wrote the opinion for unanimous court in Deprince number 1. And in Deprince 1, this court tackled the issue of the specific performance count. And Judge Rothenberg, in her opinion, had an entire section of the opinion, I think starting on page 20, that addressed the specific performance count separate and apart from the breach of
But the
contract
issue in
count.
Deprince 1 wasn't whether they had the diamond from the beginning or not. The
That's
issue, as I
correct.
understand it, was the uniqueness of a diamond.
That is correct.
And Chief Judge Rothenberg held that it was unique enough to have a specific performance count. In
That's
other words, it's not a fungible product.
That's correct.
But so it didn't address the issue that's really an issue here, which is, did you know, does the record support from day one that you knew that they didn't have the diamond in which to specifically perform?
It does not. They counsel for Starboard argued that they didn't have the diamond. When we took their corporate rep deposition, the corporate rep could not address that issue. And tellingly, when they filed a motion for summary judgment from memory, I don't believe that they found anything in support of that contention that they didn't have the diamond. I can tell you that when we first learned and had evidence that they didn't have the diamond was at the very end of the case after remand of Deprince 1. We traveled out to California to take the deposition of the supplier, and that's when we learned and we produced documentation showing that the supplier didn't have the diamond and that Starboard didn't have
Can
the
I ask you
diamond.
something? Under Diamond Aircraft, does it matter whether you knew or not knew?
No, it does not.
Is that because Diamond Aircraft specifically held that even if the claim, quote, seriously lacks merit or lacks serious merit, it still, as long as it's equitable and legal together, would preclude an offer of
That's
judgment?
correct.
So even if it lacks merit, in other words, it could be sanctionable, and there's a separate remedy for sanctions on that, still it would defeat the offer of judgment.
That's correct. And I think the court, the other important point, Judge, is that the court should look to what the state of the case was at the time that the offer of judgment was served. At the time that the offer of judgment was served, the specific performance count was heavily litigated. We retained an expert. We were ready to go and move forward on that count. And tellingly, the trial court entered summary judgment in their favor on that count, and this court reversed, finding there were issues of fact. So that was a real count. It was not a throwaway. It's different than MYD Marine or Tower Hill, where these were passing references to either an injunctive relief prayer in MYD Marine or in Tower Hill, where this court found that the deck action was subsumed as part of the contract damages action. In this case, we had a separate alternative count altogether that was very real and was heavily litigated. So we would ask the court to affirm the trial court.
Thank you.
Thank you.
Just 2 quick points. Number one, we're not suggesting that the specific performance claim was a throwaway, it was meritless. That is not our argument, as I think has been made clear. But I also want to go back to MDS for 1 second, because I have a lot of notes on this case. Having just seen it, I went back and took a quick look, just to remind the court that that was a report and recommendation of a magistrate, and the difference in that case was they abandoned their damage claim, and there was an injunction sought, a declaration that a license agreement, a patent license, was still in full force and effect. The court there, interestingly, reasoned that there was independent economic value in that other claim. It wasn't subsumed by the main claim. They were completely separate, could move forward in different directions. Very different from this case. It's all about the value of the diamond. That's why they dropped the claim before trial.
I guess what was interesting to me about MDS is that even though they made an offer that was like the one that Chief Judge Rothenberger and I were talking about,
Yes.
only directed at the damages claim,
That's correct.
specific to it,
Yep.
and not touching either in release or in dismissal the other claims.
That is correct.
And
It's
still the court said it was unenforceable.
And the reason I bring this up, I think the reason why in that case the court held as it did was because there was independent economic value in what was litigated. So it was the classic problem raised by Diamond Aircraft. You don't get outside of its grasp because this was an independent, separate claim. And in that instance, the Supreme Court has said you can't, no matter what, you can't have an offer of settlement. I believe that's why that case went the way. Well,
Plus,
it's not
the
binding.
purpose of limiting the offers of judgment to monetary damages counts, excuse me, is because you can ascertain the damages. Whereas in an equitable relief, you generally can't. In this case, it's very different because you knew the value.
Correct.
You didn't
And I
have
think
to
it is
guess
different.
at the equitable value of a specific performance claim.
That's why I think this case falls outside of Diamond Aircraft for that very reason. No mental gymnastics, mathematics, calculating, nothing like that has to be done here. It's very different, for example, from MDS, where it was a completely independent economic value in a license agreement, separate and apart from the damage claim. And I believe that's why the court recommended that in that instance, the motion should be denied for fees. I know the court's, it's a tricky issue, and there's a lot of different cases going a lot of different ways. I think this case falls outside the grasp of Diamond Aircraft, and I'd ask you to reverse the trial court's denial of fees under the offer of settlement statute.
Thank you both. We'll be in a short recess for counter change.